In the 33rd Judicial District Court of Llano County, State of Texas, Honorable J. Allen Garrett Criminal Jury Trial Docket Monday, August 9, 2021 at 8:30 a.m. CR 8059-Jury Trial at 8:30 a.m. Williams, Nelson, George.
On Tuesday, August 10, 2021, after 2 days of trial, they threatened me with prison if I agreed to not appeal my case. So I signed to probation, to not appeal my case, after signing some papers for a probation contract. A gray-haired old woman comes out and says, "I can't put him on probation, he has a warrant for the charge he just went to trial for." Judge Allen Garrett of the Llano County Court comes out from the back room and wants me to sign a PR bond for the same charge I just finished trial for, and after sentencing. I was denied due process.
So this is the PR bond. You want to talk to Nelson about that? Yes.
Liar. He never talked to me about signing a PR bond on a convicted charge after trial and sentencing.
This is the PR bond. When they indicted you, they added the second count, and I gave you a PR bond, but you were never arrested or anything on it. So if you'll sign that, it's just to clear up the paperwork so there's not some...
Well, right, I never even signed it from the beginning.
Right, that's the way they can clear the warrant out.
So how?
Because technically, you've had a warrant for your arrest, but I didn't tell them to pick you out because we're in the middle of this. That just clears the warrant out. If you see up here, it says, so your wife sees it too, it's a personal bond.
The date for today?
Yeah, just sign right there, Tony.
I've dated the back of it to today.
I just need you to sign right there, that way you get your PR bond on that second charge, so they didn't arrest you on it.
They clear their warrant and there's no...
I never signed this.
Well, you're doing it right now if you don't have a warrant.
It's a little bit unusual because...
That seems like something...
Well, I'll be clear about it. I've known about this for a while, and when you come to court, I haven't had you pick you up on arrest on a warrant because I knew it was a PR bond.
Can you have a copy of that?
Yeah, this is clear the paperwork in case someone does try to arrest you. You have a copy of it, probably have it.
Yeah.
But they're going to send it to the jail, so the next week.
Shouldn't I have been signed from the very beginning?
Yes.
Yeah, it's the first time you're in court, yeah.
Seems like a decent thing.
But
No,
Legal.
basically they can put you in jail right now.
Right.
And then what he's doing is he's keeping you from going to jail.
No.
that's what's happening.
Personal bond without deposit. Sworn and subscribed by Nelson Williams, this day, August 10, 2021.
These are the players. You got your judge.
Judge Allen Garrett.
Who works with the DA, barrister.
District Attorney Tanner Barnes.
Who works with the sheriff, bailiff.
Sheriff Bill Blackburn.
Who works with the clerk of the court.
Clerk Ashley Inge.
Who files papers, and in the police department.
Officer Zach Bowler.
Who goes out and investigates on the street or is your professional witness. This person here misrepresented his court, his files. All clerks must have a 4-year college degree in order to be a clerk of the court. To be port authority officers, to receive the vessel to be docketed at the port of the court. Now, when it's docketed, the clerk will usually look at it to see what department it goes to or reads it, but allows the modification of language from the police to come into the court, and then it goes to the Sheriff's Department, Detective Bureau to do a further investigation, maybe check up on things at a secondary level before it's given to the barrister or DA, District Attorney, to go out and then find the laws, rules, and regulations to fit the definitions that were brought to establish the violations of civil rights. Okay? And then those points of information would be given to the judge. If the modification of language from the police officer and the clerk and the sheriff are not stopped and corrected because they can't read and write and they cheated on their civil service exams, high school exams, and they're all part of the conspiracy, and the DA doesn't stop and correct it before he gets it to the judge, these guys all work together.
Attorney Bart Vana.
None of them can read and write. It's just a big act. So, are they guilty? Do they have knowledge? Well, I take their paperwork and I syntax it and I prove that everybody who touched this piece of paper in all things from the street to the jury and back to the finished order from the judge making a determination that it's a lie. It's a syntax lie. Did they have knowledge? Absolutely, because it was mathematically certified by every one of them. It wasn't just where one made the mistake, they all made the same mistake. They all acted together. If we don't lie together, we will lay together. So they all lie together. All right, now you have to give closure. Did any of these individuals give closure that they were going to use the modification of language to extort rights or to obstruct the information that was presented in the courtroom? The answer is no. None of them stopped to give closure as to use syntax to define the words and prove that they were wrong. So the closure of every one of these individuals participated. Did they port the knowledge into the court? In other words, did they docket the evidence? Yes, they were all guilty of docketing evidence to go ahead and damage somebody through fraud. Did they all participate in fiction language? The answer is yes. I have everyone that touched the documents had to sign off, so we have a signed confession that they all participated. And did they now port a correction? Once you have to give closure and port it, then you have to certify the fiction modification and port it. Yes, they all put it in. They all signed on to it. Did anybody stop and correct it? Nope, I do. Now, did they act together in a conspiracy? Anytime two or more people participate on a wrongdoing, you have a conspiracy. Now, that comes under Title 18, Section USC 3. That's an association after the fact that a fraud has been perpetrated and all individuals participated together to make that fraud go forward without obstructing. Title 18 USC 3. So the conspiracy first is brought as a civil. After the civil is argumented, then it's responsibility of the DA's office to go back and criminally prosecute everyone under conspiracy criminal, which carries a 15-year prison sentence and $15,000 fine. But when they modify language to extort money and privileges, it now goes up to $25 million and 30 years in prison. My program, however, carries 1,225 years of prison time and I think it's up to $60 million in fines. Yeah, I only got to prove one to get all of it, which is easy to do. Okay, now, did they obstruct? Absolutely. They obstructed evidence, they obstructed witnesses, they obstructed paperwork because they modified everything from the original facts. Now, did they deprive the individual from having a correct trial, correct information, correct evidence, correct due process? The answer is yes. And so all these get checked off. Did they all act together to reduce this individual beyond the point of recovery, to put him in a box in orange pajamas? The answer is yes. That's a 30-year prison sentence, Rico. Was the guy damaged? Well, I only got to prove one for damage, and I've got 1, 2, 3, 4, 5, 6, 7, 8, 9, 10 times 5. I got 50 damages. Is the guy damaged? Yeah, I think a jury would pretty well sight through that. Because you've got a chart on a whiteboard in front of a jury to take all the evidence, syntax it, define it, and educate a jury of 12. And it doesn't take a rocket scientist to figure out that somebody lied, that somebody damaged, that the court was just an illusion.
No person shall be deprived of life, liberty, or property, without due process of law, nor shall private property be taken for public use, without just compensation. Date of offense, August 3, 2020. Plea to defense, not guilty.
Fraud. I never signed, or said a plea of not guilty, before, during or after trial.